Great. Hello everyone, my name is Eva Bernet Kempers and I'm doing my PhD at the Animal and Law Chair in Antwerp, Belgium. And I will be also speaking about animal dignity, but I think it will be quite a different perspective because I will be really concerned with the legal meaning. So since we are at the conference on the theory of animal law, this is also really how I look at the concept. What does it mean? What can it mean for animal law as a legal discipline, and how should we understand it? So by means of introduction, I want to start with sharing my experience. Last week, I was at a conference about the rights for animals, nature, robots, and artificial intelligence. And what was quite interesting, I thought, is that those traits that for long were used to deny animals' rights and standing, such as rationality and intelligence, are of course to a large extent already present in robots. And you see that in relation to the discussion on robot rights, it's often those very different qualities that suddenly define our humanness, such as our vulnerability, our bodies, our mortality. So it's a bit hypocritical, I thought, that then suddenly the emphasis is so different. And this is also a bit the part of the being human that I want to explore more today in my presentation. So first I will shortly say some things about law as an anthropocentric institution and its implications for animals. Very shortly go over animal welfare and animal rights, but most of you will be aware of these approaches. I will introduce the concept of animal dignity as kind of an alternative way of looking at the questions of animals in the law. Then I will look at some traces of animal dignity that we find already in positive law today, and end with a discussion and conclusion. But my focus is really on continental law, so your jurisdictions of continental Europe, and not so much on the common law perspective. So we often say within animal law that the law is anthropocentric, but what do we precisely mean by this? I think it's very helpful to distinguish between two forms of anthropocentrism: normative anthropocentrism and descriptive anthropocentrism, which, according to Ben Milius, are slightly different in the sense that in a normatively anthropocentric paradigm, we make assumptions that assume that the human is superior and its interests are prioritized over other interests. Whereas descriptive anthropocentrism is not so much the prioritization of humans, but really the idea that the human stands in the center and everything else is defined by its relation to the human. So in reference with or by comparison with what the human is. And as you are all aware, our law is traditionally a very anthropocentric institution, combining both normative and descriptive anthropocentric aspects. For instance, already in the Summa Divisio, that stands central most European jurisdictions that divide the world into persons and things. Also, with regard to the ratio legis of the law, the motivation, the justification of the law, that is always about human interest. And you see this very clearly, of course, in the early anti-cruelty instruments. For instance, in the Netherlands, I found some cases in which people were not found guilty of animal abuse because it took place inside of the house, so nobody could see it. So then there was no problem and the judge really said, it's not about protecting claims of animals, it is only about protecting other people from seeing such cruelty. And also later, in later preparatory works, the legislator, there was really emphasized that anti-cruelty is not about claims of animals, it's really about the protection of public mores. And you see the same, of course, also in early international conventions, in which everything needs to be legitimized through human interest. Also in the interpretation and application of the law, it is about human interest. And this is the common law example, but I think it's always also a very telling example that in order to get legal standing, sometimes you have to argue through this idea of the aesthetic injury. So you're aesthetically injured by seeing animals being treated badly, which is, I think, a very good example of anthropocentric view. So this is of course a bit of an outdated picture because we are not anymore in that century, and nowadays we live in an era of animal welfarism, with which you are probably all familiar, that is very much based on this idea of limiting unnecessary suffering. What is also really characteristic, I think, of animal welfare is that it's often portrayed as an object of public interest that is protected because humans care about it. You see this very clearly also in European law, but in an example of the Belgian Constitutional Court, they also emphasize that animal welfare is a value that is shared and it needs to be protected because to protect the rights and freedoms of persons that care about the welfare of animals. So again, you see this anthropocentric line of reasoning still also because of the whole concept of animal welfare, which is primarily still an objective of public interest and not so much about animals directly. So this is still a clear example of normative anthropocentrism in which human interests value more and are prioritized. On the other side, we find, of course, animal rights. That is a more deontological approach that I think takes a very, very different view. Rights are, according to most animal rights approaches, connected to the possession of certain capacities. However, still there's some anthropocentrism in this line of reasoning because it often starts with the human as the example to which other creatures are measured. And this is not necessarily problematic, and I think in some cases it is necessary. For instance, the Stephen Wise approach to argue for legal personhood, you need to take some anthropocentric route. And I'm also not the first one to point that out. Many critical theorists have already addressed this idea that the way of reasoning that underlies much of the animal rights approach is the idea that animals need to be protected because they are like the marginal cases of human society. They are similar to humans. That was already often discussed and questioned. Do animals really need to be like humans in order to have rights? So as you are aware, I wanted to discuss animal dignity as kind of a different way of looking at this question. And I'm not the first to discuss animal dignity. There are many jurisprudential references to animal dignity. I've put some on this slide, but there are some more courts that have actually applied the concept to animals. And especially since the addition of animal dignity in the Swiss Animal Protection Act, it has become quite a topic within animal law. And there's also an increasing number of literature that really speaks about animal dignity per se. But I'm not going to read it all. You can have the slides if you're interested. And based on all these different accounts, I think we can get like a bit of a general image of what animal dignity means and how it is being used in this context. And then I think, indeed, well, a large part of it is there's a consensus that it is some kind of synonym often for intrinsic value or intrinsic worth. But I think it implies more this idea that because animals have this intrinsic value, they should be protected against instrumentalization or excessive instrumentalization. It also adds the idea of respectful treatment, whereas in welfarism it's merely about weighing pains and pleasures. Animal dignity is about treating animals with respect and care. It is non-pathocentric in the sense that it's not only about the sentience of animals. It is not so much based on only their subjective experience of pain, but also includes objective aspects, such as the idea of species-specific flourishing. So something can violate animal dignity even when an animal itself would not experience it as suffering, for instance. So this is to give some of a general idea of how the concept is being used and how I think we can understand its core meaning. So to give this some more theoretical background, I think the most compelling theory in this regard is the capabilities theory of Martha Nussbaum, which really aligns with some of the features I mentioned. And her view on animal dignity is very different from the Kantian view, because she believes that to really see dignity as related to rational capacities is actually a bit mistaken, because we wouldn't recognize a similar dignity in artificial intelligence, for instance, as we would in human beings if it could act rationally. So she argues that dignity comes prior to capacities such as rationality. It is rather grounded in the fact that we are vulnerable animals. She thereby takes a more relational, contextual approach and regards dignity as inherently connected to the capabilities that make it possible for different individuals to live a flourishing life. So there's kind of then two sides to animal dignity. On the one hand, it is the idea that every individual should be able to develop those capacities that are typical for each species and live a life that is typical for its species, but also attention for the individual, because there's different individuals within one species that may have like different preferences and different needs. And from this perspective, we can see that human dignity then is also just a species-specific version of dignity, in the sense that it really is about rationality maybe, but that is only in the case of the human species, whereas in the case of other species it may be other qualities and capacities that are important. So Martha Nussbaum's theory is essentially a political theory, but I think we can kind of get an idea of what a legal approach based in animal dignity, as informed by the capabilities approach, could look like. And I think the important aspects are then that, first of all, animals as subjects of justice matter to law for their own sakes. Animals should be then the starting point for legislation. So compared to the anthropocentric view I painted, a legal approach in animal dignity would really ground animal protection on animals themselves and their value, facilitate species-specific flourishing instead of like this focus on unnecessary suffering, for instance. And it also, I would argue, has some procedural aspects, but that I will not further discuss in the presentation today. So this is then my proposal to regard animal dignity as kind of representing a different approach that is rooted not so much in a utilitarian or deontological ethical paradigm, but more in the capabilities theory of Martha Nussbaum. The central idea is then not so much that we should minimize suffering or protect fundamental rights, but ensure respect for animals as flourishing individuals through the law. And actually, conceptualized as such, I think there's already an increasing respect for animal dignity in the positive law of today. For instance, we see an increasing number of animal protection instruments that are really about protecting animals themselves, in some cases referring to their dignity. In Luxembourg, there's also the approach now based on dignity. The region of Brussels recognized animal dignity, and in other countries it may not be literally the dignity that is recognized, but still you see a very different picture than the one I painted in the beginning. It's not about public morality, it's about responsibility for animals as fellow creatures, or about their intrinsic value. Then also substantively, you see that animal protection is kind of moving beyond welfarism. In many countries there's this notion of respect that is added. There's already some attention for species-specific flourishing. And I think always an interesting example is this recent amendment of the Dutch Animal Protection Act that states that animals can no longer be adapted to the system in which they are kept, but the system needs to be adapted to the natural needs of the animals, meaning that even like things like cutting their tail or horns will be prohibited from 2023 onwards. And also in Luxembourg, for instance, I think is interesting, since the change to a more like dignity-based animal law, there's also this prohibition to kill animals for exclusively economic reasons. And these are all examples of animal protections that are not really utilitarian in the sense that they don't involve a balancing project so much, but they really put some limit on the extent to which animals can be used by humans. Then also still shortly the slow de-reification of animals, the extraction, so to say, of animals from the category of legal things that has been taking place in a growing number of continental jurisdictions. And many animal law scholars regard this as kind of a symbolic measure that does not add anything, because it is often just stated in the civil code that animals are not things, and that other provisions still apply to animals as if they are things. But I do think that it is actually it can have quite a lot of consequences. For instance, in Belgium, in the preparatory works, you really see that it is stated that there's some kind of third category here by really challenging this summa divisio, kind of extracting animals from this binary division by saying that animals can neither be regarded as merely things nor as persons. And also judges actually do invest this provision with normative force in many cases. There's this interesting study of the civil code provision in Canada, or in Quebec it was, where you see that judges, since the addition, now take animal interest into account as kind of a separate concern, for instance in the private law context. So I think that developments such as these cannot really be explained from a perspective of protection of animal welfare or animal rights, and therefore I would suggest to regard them as a growing respect for animal dignity as an emerging principle. And this is quite an optimistic view, and I think it is not yet really an established principle, but maybe it is a start in that direction. We still have time? Yeah, well. Then, of course, it is neither a holy grail, and there's many critiques on the notion of animal dignity, not the least that it is a vague and slippery concept. But some more specific critiques are given by, well, authors like Hager, who state that it is just impossible to extend dignity to animals. Well, I think that if we see dignity in this way that Martha Nussbaum proposed, as kind of a species-specific context in which it is about, well, the capacities of different species, of which human species is just one, we kind of solve this objection, I would say. And Zuolo states that Nussbaum's account of animal dignity is in fact redundant, it doesn't add anything. But he really speaks about the moral implications, where I think that recognizing dignity in law can have actually more implications than so I wouldn't say that this is also true for the legal concept of animal dignity. Then Pietrkowski disregards animal dignity as undesirable and philosophically dubious, but he seems to be focused exclusively on kind of a Kantian idea of animal dignity. And apart from that, I think it is also just the fact that animal dignity is being recognized in law. So even if it's philosophically dubious, human dignity is equally problematic. So I think it is just necessary to discuss it as a concept so that we can have more clarity on the long term. So, well, I think that animal dignity is a concept that we can just not go around anymore in animal law. We have to accept that it is part of the body of animal law. And I therefore propose to regard it as, to see it as this alternative way of looking at the question of animals in the law, not so much based on their welfare or rights, not utilitarian or deontological approach, but really based in capabilities theory, and that it can help to, well, further animal law in positive direction. So I think it's time for animal law to start taking animal dignity seriously. And then I would like to, well, I wanted to end with a quote, but you can read it in your own time, because I think this is a beautiful example of kind of a reconceptualization of dignity done by the Supreme Court of Justice of Brazil. So thank you very much for your attention.